The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
All right, thank you, and good morning.
Good morning.
Could each of you hear me okay?
I can, thank you.
Good morning, Your Honor. Yes.
Thank you. Okay. My name is Justice Maureen Walsh of the Appeals Court, and we are here today. I want to explain a few housekeeping rules. The first is that, as you hopefully are aware, this is live streamed on a YouTube channel. So if at any point in time that you want to go back and hear the hearing, you certainly are welcome to do so, but also just be aware of that fact that this is a hearing that ordinarily would be open to the public, and by providing access in this manner, we give an opportunity for the public to be involved and to be aware of these types of cases. The second thing is, Ms. Stanley, you're a pro se individual in counsel. You've argued before the appeals court before?
I have, Your Honor. Yes.
Okay, very well. Ms. Stanley, I just want to give you a few little housekeeping tips as far as what you should be aware of as a pro se individual going through this process. One is that in a moment, the clock will appear where that symbol of the appeals court is. Each side has 15 minutes to present their case, to provide their argument. Assume, because I have read everything that each of you has provided, the records, etc., including Ms. Stanley and counsel, I'm hoping that you received it as well, a submission over the weekend that I did have an opportunity to review, along with your attachments that were so helpfully color-coded with the exhibit numbers. So assume that I've read everything, and I'll hear from you, as you have a right to be heard. Now, the second thing is that after, Ms. Stanley, did I lose you there?
No, I got you.
Okay, so after you've made your argument and don't feel that you need to use the whole 15 minutes either side, if you've said what you said and you feel as if you've kind of hit it out of the ballpark, for lack of a better word, then you don't need to repeat yourself. And if I have any questions, I'll ask them either during your argument or at the close. But whether you agree with everything, something, or none of what the other side says, you can't interrupt, okay? So there's no rebuttal. This is a 15 minutes each side, and then I'll close the hearing and I will make a decision, and you'll be notified promptly. And so once you finish your time, Ms. Stanley, then what I'm going to do is just ask you to stay on the phone. I think you're on the phone. Okay, so don't hang up after you've been done. What you're going to do is stay and then listen to counsel for Ms. Silva, okay?
Okay.
Do either of you have any questions before we begin?
No.
No, Your Honor.
Okay, very well. Then I'm going to ask the clerk to start the clock. And hopefully, there we go. And Ms. Stanley, I'm happy to hear from you.
Okay, thank you. Thank you for listening to my argument. Well, as you read in my motion, I'm a defendant appellant, Sherry Stanley, that's providing this argument because I feel that I shouldn't be having to defend myself because of all the reasons that the court, the first, that this court recognized that no appeal bond can be applied under the applicable statute MGL chapter 2396 to the extent to which it could apply, because it was well settled that this law only provides as a bond as to rent found to be owed per month going back to the commencement of the present plaintiff's claim to title. Here, the lower court judge who presided over the whole case had already rescinded any order from the past monthly payments on May 10th, 2022 in summary judging order, revising his original order and finding that there was no basis for such payments. Secondly, points out the court that had invoked review even of the attempt to apply a use and occupancy going forward under the Massachusetts statute, which is the expression of constitutional protections under Article XI of our first constitution, that equal protection is codified in the Indigent Court Cost Law, MGL Chapter 261 AG, and only in that, as the SJC held in the Edwards Petitioner 464 Mass 454 461 2013. And Your Honor, I have further examples which you have read in the motion. If I'd like to explain my situation, Your Honor, that I've been going through this since 2017 due to a divorce. The judge had given me the title, made my ex-husband put the title towards me because we were divorced because he was a, well, it's really a lot to say, but I was a victim of abuse. And that's why I was divorced. And the judge had given me title from him because he owned the mortgage and title. And from that, since 2017, I've been fighting this as indigent. I've been found that since 2017. Wells Fargo ignored me and would not give me a loan modification, which is why I'm in this situation. I've been fighting for this. I have 5 children in my home. It's my only safety net. During COVID, the plaintiffs bought my home. And as you can see, they're well known around that they buy and flip homes. This is my only home, Your Honor. And I've been trying all these years. I've learned on my own how to fight. I know my rights and I know I'm indigent, and the courts do know that. And the judges know that.
Can
why
I
I'm
interrupt for a moment, Ms. Stanley?
Sure. Yes.
Because probably lawyers do this as well. Oftentimes, we want to tell the whole story, right?
Okay.
Because it's personal to us, and because
Right.
it's right. And when I tell you that I've read everything that
Okay.
you've provided about the divorce and the title and the mortgage and the
Okay.
so and let's assume for a moment that your indigency is not an issue, okay? So accept it as true. I want to focus, if you would, on really what a major issue is whether or not your defense is frivolous.
Okay.
So tell me about what your defense is to this action.
Okay, my defense is that I have my children that live with me. They are in college. They're working on the side because they're doing internship. They don't get paid much. I'm just getting by through child support and alimony that I randomly get. It's just been a struggle, Your Honor, to try to provide for my kids, and I do voluntary work and I do what I can with that to help me through this. And I just don't have it. I'm a single mom, and it's hard, getting my kids, everything's for my kids. I provide for them to have a good, make sure they have something in life. Where I'm very big on education. I want them to learn from my mistakes, Your Honor. I don't have money to do that. This bond, and I've never had that much money since I've been divorced. I've been left in the cold. I don't have it. I don't have the money to pay a bond or to pay any use and occupancy. And that's my defense, Your Honor.
Okay. Is there anything else, Ms. Stanley, that you want me to know? You still have time.
My family and I, we get Mass Health. My kids go through college through, they get waived college because I don't have the income. And, it's a hard thing. And our home is our protection. And it's a major thing. And why we would be on the streets, we wouldn't know where to go. I try to fight with the law to get on my side for all these years to keep me in my home. And I'm doing the best I can, Your Honor, with how I can. But I don't have the money for this.
All right. I think I understand. And
Thank you.
And I appreciate all that you provide to the court. And for what it's worth, regardless of the decision that's made, I think you did a nice job.
Thank you so much, Your Honor. I've learned a lot through the years, and I give you guys credit for all this work. It's a lot to learn.
All right, well, thank you. And I'm going to now turn it over to counsel. And again, I don't want to mispronounce your last name.
Good morning again, Your Honor. May it please the court, Tom Vukmirovitz for the landlord appellee, Jane SILVA.
Thank you.
Landlord, property owner, I should say.
Yes. All right, I'll hear from you, counsel.
Thank you, Your Honor. Just very briefly, this single justice appeal arises from the appeal of an appeal bond order and is focused on the interplay between 239 sections 5 and 6, where under section 5, the law allows for or requires actually an appeal bond to a prevailing party in a reasonable amount to be fixed by the court. And that includes all damages and losses which a prevailing party may sustain by the withholding of possession of the land that it sought. Section 6, Your Honor, involves land that was acquired after foreclosure. My client was not the foreclosing party or entity, but there were purchasers from the lender, Wells Fargo, and they acquired the property as of June 15th, 2020. And Section 6, Your Honor, provides for the payment of all costs and a reasonable amount of rent of the land from the day that the purchaser obtained title to the premises until delivery of possession. And I believe that was what the court had relied upon in granting its appeal bond order. That's not to say that there was any rent. It's just the statute is that a reasonable amount of that a renting of the land would show and provide. My client moved for the setting of an appeal bond after the 10-day appeal period had expired without any motion to waive it. The housing court held a hearing and issued its order. Subsequent to that hearing, Ms. Stanley filed her motion to waive the appeal bond. And in that motion, there was nothing checked off or cited in the non-frivolous defense to be articulated. There's no issue with the indigency of Ms. Stanley, but just as a housekeeping matter, the only appealing parties are Sherry, Vanessa, and Joanna. The only party to file a motion to waive the appeal bond or rescind the appeal bond order was Sherry Stanley, and Sherry Stanley is the only one that filed this single justice appeal. In her notice of appeal to Your Honor, in addition to what she told you during the arguments, which is very similar to what she told the housing court justice, and that was directly referenced in the order, she includes issues with title and foreclosure type defenses, but those were all dealt with in the 2017 case, which my client was substituted as a party to that case. And Judge Winnick, in a very thorough decision, again, endorsed the judgment that had already entered on that. There was no appeal taken from the 2017 case by any of the Stanleys, and there's got to be some element of finality. This issue with loan modification between Wells Fargo and Ms. Stanley that has nothing to do with my client, and I'm not aware that Wells Fargo had any obligation to enter into loan modification discussion because Ms. Stanley was never the holder of any mortgage. So, Your Honor, I received Ms. Stanley's filing. I read it this morning. I think it was filed overnight. I can certainly file something if Your Honor wishes, but I would rest on the arguments and the order below. I would just say this, to the extent that Judge Winnick issued an order encompassed in the summary judgment decision that there was no use in occupancy entered because he found that the plaintiff failed to put forward evidence of any account annexed, even though my client filed an affidavit that there was no rent or any use in occupancy received. There was a use in occupancy order pending jury trial that was entered as of May of 2021. nothing was paid, and Ms. Stanley took an appeal of that, I think a couple of single justice appeals, but my client didn't pursue that issue because they opted instead to move for summary judgment. But to the extent that Your Honor feels that going back to the date of acquisition of the title is excessive and not reasonable, I would ask that at least, the very least, that the order enter for the $1,100 a month use and occupancy as of May 2021, which is the order that was entered in the Central Housing Court. So beginning June of 2021, the Stanleys were obligated to pay for monthly use and occupancy until they obtain their jury trial. That there is no need for a jury trial, summary judgment entered. So we would at least seek the amount of $13,200, which is $1,100 per month since June through June of 2022, and then $1,100 a month for use and occupancy during the pendency of this appeal as of July 2022.
All right. Thank you, counsel. And I'll take this matter under advisement, and a decision will be issued promptly.
Thank you very much, Your Honor.
Thank you, Your Honor.